Ready, shorthand legal dictation, speed with 100 words per minute, start. There is no manner of doubt that the NCTE, acting as an code, academic authority, uncode, under section 23 of the RTE Act, under the notification dated 31st March, 2010, issued by the central government, as well as under sections 12 and 12 capital A of the NCTE 19 Act, was competent to issue notifications dated 23rd August, 2010 and 11th February, 2011. Full stop. The state government was under obligation to act as per the said notifications and not to give effect to any contrary rule. Full stop. Para. However, since NCTE itself has taken the stand that notification dated 11th February, 2011 with regard to the weightage to be given to the marks obtained in TET is not mandatory, which is also a possible interpretation, the view of the High Court in questioning the 15th Amendment to the 1981 rules has to be interfered with. Full stop. Accordingly, while we uphold the view that qualifications prescribed by the NCTE are binding, requirement of weightage to TET marks is not a mandatory requirement. Full stop. Para. As a result of above, in normal course, the state would have been at liberty to proceed with the selection in terms of advertisement dated 7th December, 2012 in accordance with the amended rules by way of 15th Amendment, in view of developments which have taken place during pendency of these appeals, the said advertisement cannot proceed, and while upholding the said advertisement, relief has to be molded in the light of developments that have taken place in the interregnum. Full stop. Para. YD interim order dated 25th March, 2014, this court directed the state of Uttar Pradesh to fill up the vacancies of assistant teachers in terms of the impugned judgment. Full stop. Thereafter, on 17th December, 2014, the said order was modified and the state was directed to appoint candidates whose names were not involved in malpractices in the TET test and who had obtained 70% marks within brackets 65% for SC, ST, OBC and physically handicapped or any other category covered by the government policy for reservation, bracket close. Full stop. 54,464 posts have already been filled up in compliance of the orders of this court. Full stop. The said appointments were subject to result of these matters. Full stop. Para. It was also observed that if anyone without TET qualification is appointed, his services will be terminated. Full stop. YD order dated 2nd November, 2015, it was noted that against 72,825 posts which were advertised, 43,077 candidates had completed training and were working, while 15,058 candidates were undergoing training. Full stop. Around 14,690 posts were vacant. Full stop. It was further observed that candidates who had the required percentage of marks in terms of order dated 17 July, 2015 were to file their applications, and a committee constituted for the said purpose could verify such percentage, and if parity was found, the same benefit could be extended. Full stop. Para. We have been informed that 65,655 teachers have already been appointed in pursuance of the interim orders of this court. Full stop. Having regard to the entirety of circumstances, we are not inclined to disturb the same. Full stop. We make it clear that the state is at liberty to fill up the remaining vacancies in accordance with law after issuing a fresh advertisement. Full stop. Para. The matters will stand disposed of in above terms. Stop.